Okay, so in this video, we're going to begin our conversation about trademark law. So moving into a new area of intellectual property. So previous, we've talked about patents, which protect of course, novel inventions and discoveries. We've talked about copyright, which protects works of authorship. Now we're going to be talking about trademark law, which provides exclusive rights, which provides legal protection to distinctive marks that are used in commerce. And what do we mean by that? Effectively, what we mean is any kind of mark that communicates information about source or the source of a product or service to consumers. And what can constitute a trademark? Well, essentially anything, right? Anything that's capable of communicating information about the source of a product or service to consumers can be a trademark. What's capable of communicating information about source? Well, anything that's capable of communicating information. So that could be the name of a product or service. That could be something that's printed on a product or associated with a service. It could be the way a product or service looks, the way people dress, the way a business is designed. It can be literally anything. It can be a sound. It can be a smell in theory, right? Anything can be a trademark if and only if it communicates information about the source of a product or service to consumers, right? The definition of trademark is intentionally broad for that exact purpose, right? I mean, it's literally anything, any word, name, symbol, device, or combination thereof that essentially communicates information about the source of a product or service to consumers when used in commerce. Now, the key thing to understand about trademarks is that they come into existence by virtue of being used and by virtue of communicating information, right? So much like a copyright comes into existence simply by fixing a original work of authorship in a tangible medium, a trademark comes into existence by virtue of using a distinctive mark in commerce, right? So you become a trademark owner when you use a distinctive mark in a way that, rather you use a mark in a way that makes it distinctive, which means communicates relevant trademark information to consumers. And the role of the Trademark Office, which is part of the U.S.PTO, is not to create trademarks, but rather to recognize their existence or to predict that a proposed mark to be used in commerce will in fact be distinctive when used in the way described by a trademark applicant. Now, trademark law is predominantly federal, right? But has always existed on the state level as well. And in fact, trademarks existed as a matter of state law before they became a matter of federal law. And the basis for trademark protection under federal law is not the intellectual property clause, as with patents and copyrights, but rather the Lanham Act, which gives Congress the power to regulate interstate commerce, right? So initially, Congress tried to create trademark protection under the intellectual property clause, and in the appropriately named trademark cases, the Supreme Court said that was outside the scope of Congress's congressional power. However, the Supreme Court eventually found that Congress did have the power to federally regulate trademarks. It just had to exercise that power under the Commerce Clause rather than under the intellectual property clause. Now, how do we go about determining whether or not a trademark is implicated and potentially infringed? Well, there's lots of different ways. Typically, we do it by gathering evidence, right? And because trademark law is federal and differs from circuit to circuit, the way we go about determining whether or not a mark is in fact distinctive depends, at least arguably depends, on the circuit, right? So different circuits have different tests they've adopted in different cases, and they use those case names as a basis for explaining what the steps are that you're supposed to go through in order to determine whether or not a particular mark is in fact protected. And there are lots of different ways that trademark owners and potential infringers can go about demonstrating whether or not a particular mark is in fact distinctive as used in the world, right? So, one way we might ask consumers to determine whether or not a mark is distinctive is to explain to them what makes something a mark as opposed to not being a mark, and then ask them to, make determinations as to whether or not they think particular uses are in fact distinctive or not. By contrast, we could take a more holistic approach, and we could ask consumers, like, if you wanted to get a particular kind of product, how would you ask for it, right? What's the generic term for the product as opposed to the source identifying term for the product? Okay, so what are the elements of a trademark infringement claim, right? You have to show that the mark is valid. You have to show that you're the actual mark owner. In other words, you're the one that's using the mark in commerce. And most critically, you have to show consumer confusion, right? Because that's really the fundamental purpose, at least the fundamental justification for having trademark protection in the first place, right? The idea is that protecting trademarks is beneficial because it helps prevent consumer confusion, right? The idea is that consumers can use trademarks as a heuristic for identifying the source of the products that they're purchasing. That doesn't mean that they have to actually know what the source is. It just has to mean, it only means that the distinctive mark helps consumers differentiate products from one another, and thereby makes it easier for consumers to get the products that they actually want. In addition, of course, trademarks also benefit trademark owners, right? So part of the idea is that, trademarks are beneficial to consumers because they reduce the burden on consumers of gathering information about the products they're interested in purchasing. But trademarks also provide protection to trademark owners, and specifically, probably most importantly, they provide protection to the goodwill associated with brands, which is ultimately what a lot of companies care about more than anything else. Now, normally, ideally, consumer interests and producer interests are aligned with one another, right? Consumers value trademarks because they want to know about source. Brands value trademarks because they want to protect goodwill, and those two things line up with one another. However, it can be the case that sometimes brand interests and consumer interests diverge, and then the interesting question becomes, what do we do with trademark policy? In other words, how do we think about the way trademark policy should work in order to prioritize the interests that we think are most important? And how do we identify which interests are important as opposed to which interests are not? Okay, now, one key element of trademark law is the hierarchy of marks, sometimes known as the Abercrombie test, because it was first applied in a court deciding a trademark question related to the clothing brand Abercrombie and Fitch. And essentially, what the Abercrombie test does is provide a heuristic for courts to use, and ultimately for the trademark office as well, to use when predicting whether or not particular marks will or won't be distinctive to consumers. And the hierarchy runs from least distinctive to most distinctive. So the least distinctive kind of mark is a generic mark, which simply identifies the product class in question. Slightly more, and a generic mark can never be a trademark because it's theoretically incapable of indicating the source of a particular product because it simply identifies the nature of the product itself. Now, I would suggest that a generic mark is not really so much an ontological category as a policy choice about which marks we're going to allow brands to claim ownership of. But you can have it either way, right? Slightly more distinctive would be a descriptive mark, which describes the product in question. And unlike generic marks, a descriptive mark can be protected, but only if the prospective trademark claimant is able to show that that distinctive mark has in fact acquired distinctiveness with respect to consumers. In other words, they have to prove with factual evidence that consumers actually associate that particular mark with the source of a particular product. In other words, it's a contingent question, right? Descriptive marks are only protected if and only if the trademark claimant can show that they're actually working as as a trademark, right? And then suggestive, arbitrary, and fanciful marks are all automatically protected. There's a presumption that marks of that kind are distinctive and communicating information about source to consumers. So a suggestive mark is similar to a descriptive mark, but rather than describing the product, it suggests something about the nature of the product, right? It doesn't literally describe the product, but it suggests something the product does, or some way the product or service works, right, in a way that's aligned with the nature of the product itself. By contrast, an arbitrary mark is one that it might mean something in a different context, but it has no relation to the product in question. And then finally, a fanciful mark is typically used in relation to a word mark that isn't actually a word at all, right? As a word that was invented for the purpose of being used as a trademark and doesn't have any meaning whatsoever apart from its trademark usage. Okay, so how do brands go about showing that a descriptive mark has acquired secondary meaning? Well, they have to just go out in the world and gather evidence that, in fact, the descriptive mark in question does in fact have secondary meaning. And courts have articulated many different factors that might be considered in the context of making that determination. Broadly speaking, it's a holistic question, and anything you can gather that's going to support your claim that a descriptive mark has become distinctive is going to be relevant in making a showing for secondary meaning. Okay, so I asked you to look at the Browne v. Cococare case. Here, the question was whether or not the phrase cocoa butter formula was protectable as a trademark. The lower court said no, right? Cocoa butter formula is a generic term, therefore can't be protected by a trademark. The Third Circuit disagreed, but ultimately came to the same conclusion, right? So what did it say? It said cocoa butter formula is descriptive of the product and therefore could be protected as a mark, as a trademark, if the claimant were to show that it acquired secondary meaning. But under the circumstances, the trademark claimant has failed to show that the word mark cocoa butter, that the phrase cocoa butter formula has in fact acquired secondary meaning under the circumstances, right? So how do they go about doing that analysis? Well, they say, look, cocoa butter formula isn't generic because it doesn't literally describe the nature of the product in question. Cocoa butter is the product that's being sold in the case at hand, but cocoa butter formula, the term formula is describing something about the nature of the product and at least implies that there's something else to it, right? It's not just cocoa butter, it's cocoa butter formula, right? Therefore, it is at least descriptive of the nature of the product in question rather than just being generic for it, right? So if you were to call it just cocoa butter, that would be a generic term for the product category. Product cocoa butter formula is descriptive because the term formula kind of implies something more than just cocoa butter, right? So it's the potential to be source indicating. But in fact, the problem is that the claimant has not shown that in fact consumers associate the term cocoa butter formula with their particular product. And how does the court come to that conclusion? Well, they say, look, you don't use the term cocoa butter formula on its own, right? You're always using the term cocoa butter formula in relation to your particular branding effort, right? You're using it in relation to your brand name, not it on its own as a way of branding the product itself. In a sense, we could say that effectively the court is saying, look, you're using cocoa butter formula merely descriptively and not in a source indicating kind of way. And because you're using it merely descriptively and not in a way that would encourage consumers to think that cocoa butter formula is the name of your particular product as opposed to any similar product that would fall in the same category, you can't prevent your competitors from using the same term. In other words, we might even think of it as essentially saying, look, you've used cocoa butter formula in a generic non-source indicating kind of way. In a sense, you've genericized your own product category by not using it in a source indicating fashion.